Okay, Shannon, you can put us on the record. This is the matter of exclusive brands versus battery company. Counsel, state your appearances, please.
Good morning, Your Honor. Jason Yeard and David Warren on behalf of the plaintiff.
Good morning, Your Honor. Erica Shell, P80106 on behalf of Battery, the defendant.
Shell, like a seashell.
Yes.
James Fleming on behalf of CLDD LLC.
Okay, so we have I believe the only thing left on the docket this morning is a motion to compel production from Mr. Fleming's client. Is that correct?
That's correct, Your Honor.
And whose motion is that?
That is ours, Judge.
Okay. Go ahead.
Sure. CLDD is an important player in this case. They are a competitor of my clients. Andrew Goldstein. Some of the documents that we have produced have shown that CLDD had a relationship with Mr. Goldstein and the Claw brand prior to as late as December or as early as December of 2019. Emails also suggest that they disclosed to CLDD of the relationship with Exclusive. So while he was having a relationship, Claw has the exclusive relationship with my client, he was also having a relationship with a business relationship with CLDD. We served a subpoena properly on CLDD for information simply relevant to Mr. Goldstein and the Claw brand information. CLDD did not timely respond to the subpoena, let alone they've never objected, never moved for a protective order in this case. And based on the production and the documents that they've produced, clearly indicate that all responsive documents were not produced. Judge, for example, in addition, Judge, their own response, CLDD admits that the additional responsive documents do exist. They do say that and state that in their response. We're looking for specific documents, including licensing agreements between CLDD and Mr. Goldstein. The emails produced do not have the attachments that appear on the emails. We are looking for the leaf link information regarding the sale of the Claw products. We are looking for payments, invoices, and checks between CLDD and Claw. And none of those documents have been produced. And Mr. Fleming has indicated in his response, at least some of those documents he admittedly do exist and have not been produced. The overburden argument or the relevancy argument, there's been no motion for protective order, Judge. Basically, we gave him the benefit of the doubt and didn't move to show cause when it wasn't properly or timely. Response wasn't timely made. But when we got the response, we were very disappointed to learn that, given the additional time we gave Mr. Fleming's client, that there were clearly documents that were being withheld. So we're asking this court to order that these documents be produced, and they're outlined in paragraph 11 of our motion.
Mr. Fleming?
Yes. If you compare paragraph 11 to their subpoena, it's completely different, and it is specific. Their subpoena, the information that they requested, it is very vague, and it asks for any and all information or any and all documents that refer to or relate to Goldstein Battery Company, the Claw brand exclusive, text messages, emails, and communications. Communications, if they're not documents, you can't produce them. Text messages and emails, we did produce. There is no contract. There is no licensing agreement between my client, which is a direct competitor of the plaintiff. So what really they're doing here is trying to seek out information about who our clients are and everything else with this now expanded request for production of documents. There was nothing in their subpoena about LeafLink. LeafLink is a platform that producers and suppliers go to try to exchange products. That's available to the plaintiff also. What my client does is my client purchases packaging material from the defendant, and that's it. There's no agreement. There's nothing else. They purchase packaging material. Now, when the plaintiff wants our sales information, shipping records, attachments, to email, they're asking for, it appears to be they're asking for all of our shipping records, all of our weekly sales information, payments, invoices, and checks. They're asking for everything that doesn't even pertain to the defendant in this case. We produced what we had with all of the emails and all of the text messages, and that was according to the terms of the subpoena. When they come back in this paragraph 11 here, they've specifically asked for documents which is totally, to me, different than what their subpoena indicated. And like I said, there's no contract, no written contract. You can have an oral contract, and that's what it is. The oral contract is you supply us with packaging, and we pay you for it. That's the contract. There's no licensing agreement that's been signed by the parties. There's, on the LeafLink information, like I said, that is all just part of the LeafLink information that's out there, just like kind of like with Amazon or eBay. It's a device from business to business to be able to buy and sell products and packaging and other information. So, I mean, there's nothing else. There's no royalty agreement. There's no licensing. They don't share in any of the profits. It's merely we buy product, we buy packaging, and then use it in the course of business. Therefore, their subpoena was so vague about any and all communications. We sent it all. We sent what we had. And they also have, any information that they want on any of the sales, they can get from the defendant, if that's where they're at. I know really nothing about the litigation between the plaintiff and the defendant, except for the fact that there's this allegation of an exclusive relationship that the defendant allegedly violated. But the information they're requesting just goes beyond their subpoena, that they're requesting now goes beyond their subpoena. We feel we've complied with it. And therefore, because we complied with it, we did not seek a protective order. If they want our sales information, that's certainly proprietary. The names of our customers and clients is proprietary because they are a direct competitor. So really what this is they're upset because they no longer have a relationship with the defendant. And now they're trying to harass the company that has the relationship with the defendant. And that's really the gist of this whole case. And that's why They're asking for all of this additional information. And like I said, do we have sales information and records? Of course, everybody has. If you're in business, you have sales information. Is all of our sales information discoverable by them? No. That should be part of a protective order. That's why we didn't file a protective order, is because we answered the subpoena. We answered the subpoena to the best of our abilities by providing them. And believe me, to go back and print off all the texts and all the emails, and it's about an inch or two thick of all the documents that we did produce. So we did our best to produce everything we had. We're not involved in this litigation. The plaintiff just wants to create havoc because they feel that they've been slighted because they're no longer doing business with the defendant. And we are. So in that sense, we've done our best. And now that they're requesting other information, we don't feel that it's fair that we have to produce this.
Judge, I'll respond to.
Just a second before you do. Ms. Shell, I realize this motion isn't directed to your client. Was there anything you wanted to weigh in on?
Your Honor, I did just want to add that, Mr. Fleming's point about the relationship between my client and his client, from my understanding, that's correct. And so, I trust that his client has produced what they believe to be a response to the subpoena. And to the extent they feel that they need a protective order for confidential information that's proprietary and that is requested by a direct competitor of theirs, we have no objection to issuing a protective order if the court does believe additional production should be made.
So, Mr. Yurt,
Sure,
I'm looking at paragraph 11 of your motion.
Sure.
It certainly does appear to me, if this is, and I didn't look directly at the subpoena, but payments, invoices, checks, ACH information, you're requesting that for all of their payments, all of their invoices, all of their checks?
Not to, Judge, let's go back. If you look at number 7, that's what was requested from CLDD, paragraph 7 of my motion. Mr. Fleming did not accurately articulate what was requested. The subpoena was very limited. It was limited just to Andrew Goldstein, battery, and Claw branded products. It sought communications, contracts, financial documents, data, sales information, Judge. We specifically requested sales information, not the companies. I'm not looking for CLDD sales information related to X, Y, and Z, as Mr. Fleming mistakenly believes. That's not true at all. I'm only looking for the sales information, financial documents, data, specifically related to Andrew Goldstein and the Claw brand. That's it. And
so all of these bullet points in 11 are limited by the request that they must refer to or relate to Andrew Goldstein, Battery Company, LLC, Claw branded cannabis products, exclusive brands, and or Heidi Yahir.
Who is a principal or worker for the defendants, or is employed by the defendants, Heidi. Yes, you are 100% accurate, Judge. That is correct. It's limited, very limited in scope to that. And I have no objection to, I try to be reasonable, Judge. I have no problem with the entering of, if it's sales information, I understand. No problem. I'm cool. I'm okay with a protective order. But this information, the reason why
if it's sales information relating to the very specific limitation of the category of documents, and not general sales information.
Of course, no. It's not. It's limited.
Why would we even need a protective order?
I don't believe we do, but I just want to make sure that Mr. Fleming is comfortable. I don't think we need a protective order because it's very narrowly tailored to those categories of documents we just looked at in number 7. And I know they exist, and the reason why I was able to articulate them in a bullet point form is from the emails that we got and the text messages we got, which refer to these things. I know there has been agreements exchanged between the parties because there have been text messages referring to agreements that have been exchanged, whether they've been signed or not. I like to see all drafts of agreements between not all their customers, but just between the Claw brand, Goldstein, and CLDD. I know those exist, Judge, because they're identified in text messages. They just haven't been produced, Judge. That's where I got this category, this bullet point list, which is limited to that narrow category of participants. I didn't just pick it out of the air. I requested sales information, limited sales information.
All right. So it looks like this is essentially a supplemental request.
No, Judge. No, Judge. I did request for all sales information and agreements and financial documents related to, and this is what I have in bullet points is what that is. What is their sales information, the LeafLink? What is their agreements? It's not supplemental. It's exactly what was requested in the subpoena.
Well, I didn't mention LeafLink in the subpoena, Your Honor. And LeafLink information, okay, how vague is that? LeafLink information would be concerning Claw or Goldstein's products. LeafLink information is, like I said, it's something that you put out there. LeafLink is like your eBay, and they put it out there for people between the buyer and the seller. That's all.
We've been on
their website that
we've discussed this with LeafLink.
I don't know what else they want. So
they want. It sounds like they want LeafLink information related to Andrew Goldstein, Battery Company, Claw branded cannabis products, exclusive brands, and/or Heidi Yahir. Not all your clients' LeafLink information, just that LeafLink information.
Okay. Information is the word that I'm having a problem with. It doesn't say LeafLink documentation. It's information. So do we want us to just print off what is on LeafLink as far as what is being offered as far as the product? So
well, let me ask, from what you're telling me, LeafLink is a publicly accessible store.
You have to
for
be
finding these kind of products.
Judge, that
business
is
to business. You have to have a password and a username, and then if you've paid the fee, then you can go onto the site. But once you,
I got you.
But
It's not publicly accessible, but once you are subscribed to it, you can access anything that's on it.
That's not true, Judge. We've dealt with. That's not true, Judge. They have.
I wouldn't say anything. I don't know. I've never been on it.
He doesn't know. We've been.
Right. Let me.
It's like
Mr. Yurt can clarify. Go ahead.
Yeah, LeafLink, Judge. We've dealt with this issue in this case. LeafLink, it is like eBay, but the CLDD is the only one that has access to the sales information, the actual sales, the dollar sales of the Leaf or of the Claw Goldstein product. I can't go on. It's my understanding, because my clients are also on LeafLink, that you can't go on. I can't go on as a user, even if I'm logged in, and seeing the sales revenues of the products, the Claw products sold by CLDD. I don't have access to that information. I don't have access to these draft agreements that I know exist that haven't been produced. I don't have access to any of this information, Judge, at all. This is a very limited scope and universe of documents I'm looking for. I don't want all their business records, Judge. That's not what this is about. I would never request that because it's overly broad. I just want these narrow scope of documents that I do know exist that haven't been produced. And that's it, Judge.
On the LeafLink, what we're talking about then is just CLDD sales to the plaintiff.
Well, no, not to the plaintiff. It's CLDD sales of the defendant's products.
To whoever they sold them to?
Well, yeah, we want to see the sales of the defendant's products. CLDD sales of the claw.
Well, wait a minute. Wait, if they're selling,
It's the sales information related to the defendant.
if they're selling, uh, claw branded products, presumably they're selling them to their own customer base. And presumably they're selling other products to those same customers. Am I right? Or is this just a one product?
No,
Yes,
but
I think you're on.
all I'm looking for are the sales. I don't want the sales of the other CLDD products. I just want the sales of the very limited of the Claw Andrew Goldstein products.
Is there any reason that CLD shouldn't be allowed to block out the identity of its customers? Otherwise, they're essentially giving you a customer list.
I don't mind a protective order, and I don't mind that either, Judge. I don't mind that at all.
Well, not just a protective order, but blocking out the customer information.
They ought to be able to redact the names of the customers. Otherwise, they're giving you their customer list. I can see why they wouldn't want to do that.
No problem, Judge. That's no problem. I'm just looking for the sales data and sales information related to the leaflet. That's no problem. I think that's reasonable, Judge. I have no problem with that.
All right. What I'm going to do is order production of the bulleted items on number 11 as limited by the language in paragraph 7 of plaintiff's motion. And I'm going to permit CLDD to redact any information that discloses the identity of their customers, seems to me that should be sufficient.
Or
Thank you, Judge. I appreciate it. I'm glad we were able to resolve the first motion too. We try to make your docket as light as possible.
Appreciate it. Was there anything further, Mr. Fleming? You were about to say something.
would we also redact any other information that obviously doesn't pertain to the defendant?
Well, if there is somehow contained in the information you're provided, information unrelated to the specific categories that are requested, that is in fact disclosing proprietary information, I would allow that to be redacted as well. Clearly, your client's not a party to this. I get that, but this information, at least as limited, is relevant to the claims that are made in the case.
I'm looking at the list and I see, some of that payments, invoices, checks.
That's limited specifically to by paragraph 7.
Okay.
To Battery or Claw Brands and Andrew Goldstein. Not every single check that CLDD writes.
I understand that now. I understand the court's ruling on that.
In any of the payments, invoices, checks, ACH information that identifies CLDD's customers, you can redact.
I guess now I'm a little bit confused. I thought it was payments involving the defendant, but not the other customers. Because all we do is buy packaging material, use the packaging material, put a product in it, and then give it to the customer or the person that ultimately sells it. So in that sense, it should be just, it's not payments that we've received from our customers, it's payments that we've made to the defendant.
Is that correct, Mr. Yurt?
No, Judge. We want to see payments for the products just related to this specific. I don't think Mr. Fleming maybe doesn't. The products that what they're selling is Claw branded products as well. That's what CLDD is selling. So we'd like the sales information related to the Claw branded products. Just limited to Claw, not
So
limited.
now we're getting into proprietary information of what we sell.
Hold on. Mr. Fleming has said consistently that all they're buying is packaging, but not whatever it is that goes into the packaging. Is that distinction? I'm having trouble understanding how that distinction bears upon the rest of this case, because I thought it involved marijuana products and derivatives.
That's what they're putting in these products. They're marketing them as Claw products. So what CLDD is selling are Claw branded products, and that's why we want that sales information so we can see the amount of sales of those products.
But we don't have any type of
damage because part of our damage analysis is those sales should have been our sales.
They want to find out what our sales of all the products are, which has nothing to do with our agreement with the defendant. Our agreement with this defendant is you deliver us packages, we put the product in the package, we sell it to somebody else. What we sell to somebody else is proprietary.
It's not proprietary. Go ahead.
So hold on. So the packaging itself is Claw branded. Is that what you're saying?
Yes, Judge. The packaging that they're selling is Claw branded products.
I got you.
So you'd be able to. I don't want all their sales data related to the company. I just wanted the sales information, which we've been talking about, related to the Claw branded products, which CLDD is selling. They're selling Claw products. It's not just a water bottle without a label on it.
All right. So the Claw products and information regarding sales of the Claw products is all you're asking for.
Yes,
with
Judge.
respect to sales information.
Yes, Judge.
And the identity of the customers to whom those products are sold can be redacted.
Sure. I have no problem with that. That's very reasonable, Judge. I'm not looking for that information.
But they're looking for information on what we're selling, how much, how often. To me, it's.
I think ultimately it's how much is what they're mainly interested in, because that can help them in establishing their damages. All right. So as I indicated, what I'm ordering is the production of the specific items contained in paragraph 11 as modified by paragraph 7 with the specific ability to redact any disclosure of customers or other proprietary information. Mr. Fleming, how much time do you think your clients will need to respond to that request? Your client?
Quite a bit. The shipping records, for example, to be able to go back and look at all the shipping records. Are we talking about then shipping records to our clients? Are we talking about shipping records from?
Yeah, let me ask, Mr. Yurt, if you've got the sales, why do you need shipping records? I mean, I don't want to put this non-party to a bunch of work.
The shipping records.
shipping of
The shipping records I'm looking for, Judge, are the shipping records of receipt of the claw materials to CLDD, because I want to see the dates. I think the dates are relevant.
So the
I got you.
shipping,
When they ship those to their customers, you don't
Right.
need that.
Yeah, yes, Judge.
All right, so you can.
That's correct.
You can exclude that, Mr. Fleming.
so exclude shipping records.
From
Exclude shipping records of shipments made by CLDD, but include shipping records for purchases from purchases of this product.
We wouldn't have shipping records necessarily when the defendant sends us packages.
But if you do have them, you need to produce them. I'm not asking you to produce anything you don't have.
Thank you.
So this information, Judge, is going to be necessary for us in connection with depositions in this case. Obviously, it's a material, and I think the discovery deadline. David, do you remember when the discovery deadline is?
Alas, I do not. It's sometime in January, I believe, but with the holiday and the lockdown, and now the further delay, I don't know the answer to your question.
Is there a jury demand in this case?
I think so.
I don't.
Well, Judge, you would probably know better than I would just sitting here.
Well, I could find out. I just obviously don't know off the top of my head.
Yeah, I'm trying to look right now, Judge. That's why I'm looking away.
Judge, I'm asking this for other cases. If there's a civil case before you with a jury demand, we're looking out to when we would actually have a jury trial.
My best guess now would probably be April at the earliest.
Okay.
And we don't know. We just don't know how quickly the vaccine's going to get disseminated, how effective it's really going to be based on how many people are actually taking it. Are we going to be back to normal by April, or that's when we gradually begin getting back to normal? So I don't know. But
so if we
based
have
on
any,
where I sit,
sorry.
if you got a jury demand in, you're not going to get a jury trial until April at the earliest. And the reason I mentioned that is if there's a need to push out discovery, I don't have a problem with doing that. There is? All right, there has been a jury demand. So if additional time, I want to give Mr. Fleming's client ample time to respond. Sure. And I don't want that to put the parties in a bind with respect to completing any discovery that the information obtained from Mr. Fleming's client might lead to. So I don't have any problem extending your discovery if that becomes necessary. I'm going to give Mr. Fleming's client 21 days to respond to this request.
Your
Okay.
Honor,
It's reasonable. Thank you, Judge.
in the bullet points, it says attachments to emails. Now, we sent emails, and I would like Mr. Yurt to specifically, because he's indicated that, specifically tell me what attachment to the email. Maybe he can point it out, go through, highlight it,
Judge,
give me the date of the email or
Judge,
something of that nature, because that's requiring me now to go through every single email to see if there was or wasn't an attachment. And, sometimes you get an attachment, but it's really not an attachment. It's just like your logo or something like that. So I need something specific.
Judge, if this client should have been included in the first place, it should be produced now. I'm not sure why.
Well, there's no reason why he can't provide me with that information specifically.
Why is he putting? It's his client's documents.
We can look for it and get it. The same goes for text messages. If he says a text message or email string which isn't complete, well, show me where it's not complete. When you have an email string, it can go on forever.
He needs to, Judge, his client should have produced this to begin with. And
We
his client
produced
should go,
everything we had.
his client should be
And-
going
and
back
I'm
to
not
the
gonna go
emails
through and
and
guess.
producing the
Hold
documents
on,
correctly.
hold on.
If there's
I've
attachments,
made my, I've
Okay.
made my ruling. I'm not going to address any more this morning.
thank you, Judge.
Thank you, Your Honor.
You're welcome.
Your Honor, are you preparing the order?
No, I'm not. Mr. Yurt's going to prepare the order.
Absolutely, Judge.
All right, thank you.
Thank
I
you.
might need more time than 21 days if I have to go through all the emails and texts.
If you need more, you can petition for more.
Thank you.
Hey, Jim, I have no problem giving you more time if you need it. Just pop me an email, no problem.
You know, I could get it done a lot faster if you if you specifically referred me to a date when an email that you feel is not complete.
Jim, if you need more time, please let me know. Always looking to be reasonable. Thanks, Judge LaFlamme. Appreciate it.
Thank you, Judge.
Have a good day, everyone.
Your Honor, on that one, Mr. Yurts, Warren was present too, right?
David Warren, yes.
Yeah, Mr. Yurts, that's the one that I didn't get.
Oh, okay. Yeah, he's the one that did all the arguing.
Right, okay.
They're both from the same firm.
Gotcha.
Okay, let's see. What have I got left? This is an ADR conference?
Yes, Your Honor.
You couldn't work it out?
We thought we did.
Well, then why are you here?
We were advised that
just-
you still wanted to proceed, Judge.
I don't know who advised you that. I can tell you, I think the scheduling order is pretty clear. If you agree on a form of ADR, you submit a form that we supply for you, and there's no need for a conference. We only have a conference is when you can't agree. So have you already submitted a proposed ADR order?
We did.
All right, well, sorry for the confusion, gentlemen.